All right, Lamont Harrison Lemon, the second. That's the gentleman with the Fez hat on. Headgear.
Before we even get into the charges, let's talk about what kind of courtroom we're stepping into here. Judge Perkins' courtroom has become something of a recurring stage for sovereign citizen performances, and if you've seen even one of these cases, you already know the playbook. What you're about to watch isn't a legal defense, it's a script. A script built on internet myths, misunderstood contract law, and the belief that saying the right magic words can somehow shut down the justice system. Today's main character is Harrison Lemonbay, or the second, or the third, or the lowercase version, depending on which sentence you catch him in. He enters the courtroom wearing a fez, speaking in riddles about strawmen, principal debtors, and special deposits, convinced he's found a loophole judges somehow missed in law school. Meanwhile, Judge Perkins comes in calm, professional, and patient, but make no mistake, that patience has limits. This case starts with confusion, escalates into pure legal fantasy, and ends with a decision that will likely surprise absolutely no one except the defendant. Watch closely how the judge offers clear options, explains consequences, and slowly realizes is talking to someone who isn't listening at all.
Is he connected to audio?
It appears so.
Lemonbay, Harrison Lemonbay. Can you hear me, sir?
Can you hear me?
I can hear you. Good morning to you.
How are you?
Okay. Are you the second or the third?
I'm here on behalf of the third.
The third. Okay. And I guess it's the second as well. This is the city of Detroit versus Harrison Lemon Bay the third. Straight that. This is the state of Michigan versus Harrison Lemon Bay the third. Case number SX 419-5968. Counts 1 and counts 3. Appearance for the record, please.
Elwood S. Berry Jr. on behalf of the defendant. State your full name, sir.
Your Honor,
Mr. Berry, I think he's representing himself.
Your Honor,
Yeah.
Okay.
Yeah. All right. And add count 3 to that. Add count 3 to that record as well. Or count 2 to that. Or 1 to that record as well. So count 1, 2, and 3. Let me have that other. I believe. State your name for the record, Mr. Lemon the third.
Yes, I am Harrison Lamont Bay, all lowercase letters. And I'm here on behalf of Harrison Lamont the third.
All right. Well, I've never heard of it.
This right here is one of the most common sovereign citizen tactics, and it's where things usually go off the rails fast. The idea that spelling your name in lowercase somehow creates a separate legal identity is completely fictional, but it's been recycled endlessly in online forums and pseudo-legal videos. Harrison genuinely believes that by rejecting capital letters, he's stepped outside the court's jurisdiction, as if formatting overrides reality. Notice how Judge Perkins responds. He doesn't laugh. He doesn't snap. He calmly asks what it means, giving Harrison every opportunity to explain himself. That's not weakness, that's professionalism. Judges know that letting defendants talk often exposes the flaws in their arguments better than interruption ever could. What makes this moment important is that it sets the tone for everything that follows. Harrison isn't confused. He's committed to a belief system that doesn't recognize how courts actually work. And once someone locks into that mindset, logic stops being persuasive. From this point forward, every answer he gives will circle back to this imaginary legal separation, no matter how many times the judge tries to ground the conversation in reality.
The name is to be spelled with all lowercase letters, not all capital letters, not part capital and lowercase, strictly all lowercase.
So today is the date and time set for a pretrial in the matter. How do you want to proceed, sir? I know you filed some documents with the court, and I did have those up in my chambers. But how do you want to proceed?
Your Honor, I'm the surety on behalf of the principal debtor, strawman Harrison Lamont III. I've given the court notice weeks in advance. I'm here to tender a special deposit to the court and make the clerk fiduciary, the prosecutor, as well. And I'm looking for a plea of release today. Will you grant a plea to release?
No. I can grant you a pretrial. I can grant you the opportunity to speak with the city attorney, or I can grant you a trial date by judge or by jury.
Yeah. So
What would you like to do, Mr. Lemon Bay?
well, do you mind if I ask a couple of questions?
Here's where the sovereign citizen script goes full throttle. When Harrison says is acting on behalf of the principal debtor strawman and wants to tender a special deposit, he's borrowing language from misinterpreted commercial law concepts that have absolutely nothing to do with traffic or misdemeanor cases. This isn't strategy. It's cargo cult law, where repeating complex-sounding phrases is mistaken for actual legal authority. Judge Perkins responds with a simple, unmistakable no, and that word matters. Courts don't negotiate reality. There is no plea of release option sitting in a hidden menu. The judge immediately redirects the conversation back to legitimate paths forward: pretrial, speaking with the city attorney, or setting a trial date. Those are real options, grounded in law. What's fascinating is that Harrison doesn't hear the refusal as final. In his mind, the judge just hasn't recognized the correct terminology yet. This disconnect, where one side is operating in real law and the other in fantasy, is exactly why these cases grind to a halt.
As you gave the name, I heard you mention a few different names. I heard you mention Harrison Lamont Bay the third, and then a Harrison Lamont the second, and various different names. I just want to make sure that I'm clear on who or what it is that we're here to discuss, because I don't want to speak on behalf of.
It does have an error. It does have an error. It appears to be an error on the computer here. So entry date, one of the counts was entered into as one count was entered into as Harris Lemon third. The other count was Harris Lemon second, and the other count was entered Harris third Lemon. So I think that's just a typo. There's the nature of the offenses is the misdemeanor case is driving without a valid operator's license, no ops on person, and that is a 93-day punishable by the maximum possible penalty, 93 days in jail and or $500 in fines. And you have two civil infractions, one expired plates and the other one speeding at 16 to 20 miles an hour over the speed limit. So those are the nature of the charges. I'm going to offer you an opportunity to mitigate this by taking the better driver's course.
This is the judge doing something very deliberate, slowing the entire proceeding down to make sure the record is clean. When Judge Perkins asks who exactly they are discussing, the second, the third, or another variation, he's not confused. He's establishing clarity, so there's no room for later claims of misidentification or procedural unfairness. Harrison, however, interprets this as validation. He believes the judge's attempt to untangle the mess proves the system is flawed, rather than acknowledging that the confusion is self-created. The sovereign tactic thrives on complexity. If things feel chaotic, they assume they are winning. But courts don't operate on vibes, they operate on records. And once Judge Perkins identifies the issue as a simple clerical typo, the magic evaporates. The mystique of multiple identities collapses into something mundane, a name entered incorrectly in a database. That's not jurisdictional warfare. That's paperwork.
You choose to, and I can give you time to do that. If not, you can set it for a trial date or whatever set it for a trial date or speak with the city attorney today. What would you like to do?
I'm really, again, I'm ultimately I'm here to tender special deposit and settle the charges, you know, make the clerk fiduciary.
Well, you settle it by pleading to, in taking a plea today, paying the fines, or taking it to trial, see if you can do better at trial. You have a right to a trial by judge or jury, and that's it. Those are your only options, sir.
I'm looking for a plea release. Are you stating that there's no offer of equity in this matter, Your Honor?
I don't know what you're talking about. All right, we're gonna
Sir,
move on.
would you-
So I don't have time for this.
Would you
I
like
got a
to
lot of-
speak to an attorney? Would you like to speak to an attorney, sir?
I don't. I'm
You don't?
not asking for counsel.
Okay,
Not-
well, we're gonna pass the matter and we're gonna move on. And he can just watch and see how it works in here. Because I have too many people that are waiting that want to be heard and hear their claim. And I don't understand what you're saying. I've given you your options and you can sit back and ponder those. I'll give you time to ponder those options. Other than that, sir, I don't know what else to tell you. All right, let's move on. Next time. No, I've already answered the questions I'm gonna answer. No, please mute your device, and you either take the offers that I've given you, speak with the attorney, or take the deal, or set the matter for a trial date. Those are your options.
Let me set the matter for trial.
Set the matter for trial. Okay, I'm gonna give you a trial. I'm gonna. Do you want trial by judge or jury, sir?
Your Honor,
This is the moment where reality fully enters the room. Judge Perkins lays out the actual charges plainly: driving without a valid license, expired plates, and speeding significantly over the limit. No hidden contracts. No secret trusts. Just traffic and misdemeanor violations with real penalties attached. And then, this is key, the judge offers mitigation. A better driver's course. That's not punishment. That's an off-ramp. Judges don't have to do this. It's a chance to reduce consequences and resolve the matter efficiently. For most defendants, this would be a relief. But for someone committed to sovereign ideology, accepting this offer would mean acknowledging the court's authority. And that's unacceptable within the belief system. So instead of taking the lifeline, Harrison rejects it, not because it's unfair, but because it contradicts the narrative he's invested in.
Jury trial. Can I get a jury trial date, please? Let's do June the 2nd. June the 2nd. We'll be doing this in the afternoon as well.
Well, we gotta set a pre-trial first.
Yeah, we'll set a pre-trial. So your next court date is going to be a final pre-trial, sir. Final pre-trial will be June the 1st, 6/1/2023 at 8:30. And then we'll set the jury trial date for the next day at 9:30 on June the 2nd. So your next action date that you need to appear is June the 1st at 8:30. And then the next day we'll have the jury trial at June the 2nd, 2023. I have received your motions. If you have any more motions, make sure they're in before the June the 1st date, and then we'll proceed with picking a jury and setting a jury panel at 9:30 on June the 2nd. If you don't have any further questions, Mr.